Ladies and gentlemen, welcome to Panel 3, The Lasting Legacy. Please welcome Director of the Ronald Reagan Institute, Mr. Roger Zakheim.
Good afternoon. And before we move to the third panel, The Lasting Legacy, I just want to take a moment to again thank all of our Reagan Foundation trustees, but in particular, Mr. Ted Olson, who is a driving force behind this celebration. Ted, thank you so much for giving us this opportunity. Throughout today's discussion, we've reviewed the historical context of Justice O'Connor's life and career and captured its significance. We've mined the decisions and commented on the jurisprudence. Now we'll turn to the legacy and discuss the lasting contribution and the ways in which we will continue to see her hand in law and in the civic life of this great country. About 15 years before he nominated Sandra Day O'Connor, gubernatorial candidate Ronald Reagan delivered one of his earliest and most consequential political speeches at a Law Day luncheon at the University of Southern California. In 1966, outlining his vision of the creative society, Ronald Reagan advanced an initiative to take judges out of politics and articulated his vision of an ideal judge. He called for judges to be, quote, men with ability, men of honor, and men who are fair-minded. Well, when it came to his first nomination to the Supreme Court, President Reagan certainly delivered a nominee who realized his vision, minus the men part. Listening to the sessions earlier today, we've all gotten a taste of Justice O'Connor's remarkable ability and the honor she brought to the court and the fairness and decency in which she approached her life and her craft. I like to think those would be the very qualities that our 40th president would offer as the lasting legacy of his first nominee to the Supreme Court. As one of Justice O'Connor's clerks wrote, quote, without fanfare, she hones her craft, deciding individual cases, answering concrete questions, and in the process, providing clear and enduring answers to the most important questions of the day. She was honorable because she judged and ruled without fanfare. She was fair-minded and therefore able to decide individual cases, answering concrete questions without being blinded by ideology. And her ability allowed her to provide clear and enduring answers to the most important questions of the day. It seems to me then that the legacy our next panel will discuss resides not just in what she said, but how she did it too, with honor and fair-mindedness. This dichotomy between the what and the how gets to another facet of Justice O'Connor, her commitment to educating and cultivating a nation of civic-minded citizens. As was referenced before in her public letter to Americans nearly 1 year ago, Justice O'Connor charged all of us to work together and to, quote, commit to educating our youth about civics and helping young people understand their crucial role as informed, active citizens in our nation. This is what President Reagan called informed patriotism, and why the Reagan Foundation has always had a civic mission, starting with the Annenberg Center, dedicated to civic learning over 10 years ago. Inspired by our 40th president and guided by the example and charge of Justice O'Connor, I'm honored to announce today that the Reagan Institute has launched a Center for Civics Education and Opportunity. This center, led by our own Janet Tran, and operating out of the Reagan Institute offices in Washington, D.C., will proudly embark in the work of engaging and supporting the next generation of informed, active citizens in our nation. We look forward to working and partnering with all of you on this truly noble cause in the coming months and years. and we sincerely hope you'll enjoy the next panel, The Lasting Legacy.
Oh, I can't see. Okay, let's make sure everybody can hear us. I guess you can, or you'd be saying something. I think we're the biggest panel, so we're going to just dive right in. And for those of us of a certain age, Sandra Day O'Connor was the rope that we had long hoped would be cast our way. A rope to cling to, a rope to use to climb up and through that glass ceiling. In disclosing her Alzheimer's to the country last year, Justice O'Connor was, I thought, typically forthright and aspirational. I hope that I have inspired young people about civic engagement and helped pave the pathway for women who may have faced obstacles pursuing their careers, she wrote. Now, of course, she did that and way, way more. And so now, even though we have way too little time, we're going to talk about her lasting legacy. And I'm going to start with Chief Justice McGregor because you knew her longer than anyone here from her days as a state legislator through her nomination and first days on the Supreme Court into her retirement. And I am wondering how you think she changed over time. I don't mean ideologically necessarily. I mean in terms of her own self-confidence and her own being as a justice.
Yeah. Well, one thing that didn't change has been mentioned earlier, and that is the fact that she brought to the Supreme Court the same characteristics she brought to every job she had. Her work ethic, her intellect, her demand that everyone do the best they could. But what I think changed the most, and it probably was a result of growing confidence for her. Those of you who remember 1981 know there were a lot of people who weren't very sure that this woman that they may not have heard of from an intermediate appellate court in Arizona could really do the job of a Supreme Court justice. And she very quickly proved them wrong. But I think what happened over the next quarter of a century is she saw more and more what she could accomplish, what impact she could have. And she was very concerned about attacks on the rule of law and the independence of the judiciary. And she learned that when she went and talked, people would take from her things they might not pay so much attention to if someone else said. And so both domestically and internationally, she used her celebrity, I guess, but her persuasive abilities and the fact that people would listen to her to really make an impact in those areas. And I think you see the progression of that from the time she started on the court until she left the court and then continued that into her retirement. So that's where I would have seen the greatest change.
Meryl Chertoff, you and I were, when we were talking prior to this panel, you talked particularly about her devotion to judicial independence, which is not only to some extent under attack in this country, it's under attack in other countries that we identify with today, the UK, for example. And I am wondering what she did concretely, and I'm told she was pretty fearless in her foreign visits.
Well, when she left the court, the justice said that she felt she had 5 years to really accomplish something in her post-court career. And so at Georgetown Law School, she started a project that was devoted to two things: civics and the independence of the judiciary. And about civics, she said the practice of democracy is not passed down in the gene pool, but needs to be learned anew by each generation. And so we incubated with her what became iCivics, but before it was iCivics, it was called Our Courts, because she felt that there was a fundamental misunderstanding among young people about what judges did and the role of judges in democracy. And so the two things really came together, that concern about the independence of the courts and about civic education. She really felt that it was her responsibility, and she had the bully pulpit, to explain to young people what the role was of judges to maintain the rule of law in a democracy. And the education role is something that she did not only in the United States, but abroad as well. And she traveled with Ted Olson, who is here, on Sealy. She traveled to Asia. She traveled to Africa. She met with judges every place that she went. And she believed that our judges could be an asset to talk about judicial independence. And of course, today, it may be that there are things that we can learn from judges abroad, and I think that she would want to be.
You told me that she once went toe-to-toe with some guy in China, I think it was.
Not in China. It was in Judy Areen's backyard in Bethesda. But it, but it was,
so she needs to leave.
It was a judge of the Chinese court, and she had traveled in China, and the judge was quite insistent that in China, the Supreme People's Court had the last word, and she was equally insistent that, in fact, the last word lay with the People's Congress. And of course, she was correct about that, but she was willing to go toe-to-toe with the professor from the Beijing University.
And yet she said, Ruth, that the single decision she really regretted was her vote that she regretted was her fifth and decisive vote in a case declaring unconstitutional state laws that barred candidates for judicial elections from campaigning about controversial issues that might come before them. And that was in 2002. She wasn't a newbie at all. So why did she do that?
Well, I think, and I don't know, I do know she regrets that vote, but I think her goal, she wrote a concurring opinion, and the concurring opinion said, in essence, look, states, if you elect judges, you set yourself up for this problem. And we shouldn't try to maintain judicial independence by limiting what judges say in elections. And her hope was that states would think about this and would move from direct election of judges to merit selection, of which she had been very supportive beginning when she was a state senator in Arizona. It turned out that that didn't happen. There was a little but not a lot of movement toward merit selection, and what did happen was what she feared the most. Judicial elections became more partisan, more money flowed into them, judicial elections looked more like legislative elections and less like something that an independent judicial candidate would say. So my own feeling has always been she hoped that by concurring in the opinion, she could say, this is what's going to happen if you have elections. So states, be realistic, be practical, and move away from them. It just didn't work out that way.
You know, after she retired, one of her main decisions, upholding the McCain-Feingold campaign finance law, was subsequently struck down not that long afterwards. Yeah. I wonder what her thoughts were about that.
Well, it happened that I was with her when she learned of the Citizens United decision. And she very seldom said anything that was critical of the current court, then current court. But she commented that they don't understand and this will not work out well. And she didn't say much more, but if you look at the two opinions, McConnell and Citizens United, I think you can see why Citizens United was not an O'Connor kind of opinion. First of all, it overturned a decision just from 7 years earlier. You know, what happened to stare decisis would have been Justice O'Connor's question. It also, the McConnell opinion that she and Justice Stevens co-authored, had given great deference to the legislative judgment as to whether spending money in campaigns in certain ways by certain parties at certain times could be harmful, could raise the specter of corruption or at least the appearance of corruption. And in McConnell, they had accepted that argument. Well, in Citizens United, the court just simply said that's not true. There won't be any corruption, so we don't have to worry about this. And that, again, was, first of all, no deference to the legislature, and simply saying something was different than had been in another opinion without any reason for it. And the other thing I think you would see that would trouble her about Citizens United is, we've heard talk from the other panelists, how Justice O'Connor really tried to deal with the four corners of the case presented to her, not make any sweeping comments. And Citizens United, of course, the opinion went far beyond the question initially presented to the court. So I think if you compare the two and look at Justice O'Connor's jurisprudence, it's pretty clear why she would have thought it was a bad opinion and why she also, given her more practical approach, believed it wouldn't work.
Kathleen Smalley, you were in her first crop of law clerks. And if there's one thing I learned from Evan Thomas's book, it was that as much as Justice O'Connor was, I don't think I couldn't say terrified, but certainly understood the challenge before her as she undertook this position, having never operated in a federal court in her life, basically. She was thrilled to be playing in the big leagues and that she could have some effect. Could you talk about that a little bit?
Yeah, it was very, very visible in the way she conducted herself around chambers. There was a fair amount of stress because all of the issues were new, and we felt like we worked harder than any other clerks any place in the court because we had to get her prepared on issues she hadn't seen before. But when she came back from argument, or when she came back from conference, or when we circulated an opinion, she was almost, singing her way back into the chambers. She was so exhilarated by what she had done. If she'd persuade somebody to join one of our opinions, that was a big moment and a cause for celebration, and you could tell that she really felt like she had made it. She'd made a difference.
So I'm going to intervene here to ask you, how, when she left the court and founded ultimately iCivics, and you've been on the board since the beginning, how do you think her vision of all those years of everything from national security to abortion, I mean, the issues in which she played a decisive role are as wide as this country is. I wonder how her vision animated her idea of iCivics.
Well, I think it comes partly out of her time on the court and partly out of all the other things she did. At the court, she decided important cases, but she's often said that iCivics is her greatest legacy. And a lot of people have doubts about that because it seems a little bit counterintuitive, to say the least, that you're the first woman on the Supreme Court, but your greatest legacy is the nonprofit that you form after you retire. But one of the things I learned clerking for Justice O'Connor is that if she says something that's counterintuitive, you should stop and think about it because she is probably right. And I think in this one, she may well be right, that this comes out of her love not only for the court as an institution, but where the court fits within our overall democratic structure. And coming from experience in the executive, in the legislative, at the federal, at the state level, she really understood at a deep level how it all works and how dependent it all is on having an educated citizenry. You can't have a functional democracy if you don't have citizens who can play their role in it. And I think what she saw with increasing pressure on judges that led to the project that Meryl was talking about is that people don't understand what judges are supposed to do. They don't get it that in our system it's not supposed to be a partisan decision. And as a result, we're in danger of losing that functioning democracy. So her decisions on the court obviously are a really important legacy, but decisions can be cut back, can be overturned. Some of them have a shelf life. They describe in some of the cases that this is a current problem. We won't have this rule 25 years from now, maybe. But the need for our functioning democracy goes forever. And today, I think we see that we have a citizenry that isn't well educated because we've kind of eliminated civics from the curriculum. And as a result, students don't know what their role in our democracy is. What iCivics has done after Justice O'Connor focused on this problem after she came off the court is to create an interactive set of simulations where students can play roles in our democracy and really learn how it's supposed to work. And we are currently reaching over 6 million students a year. We haven't yet accomplished what the Justice set as the goal of reaching every student in America, but we're on our way. And I think that the Justice's family has been actively involved in this. When she stepped off the board actively, her son Jay joined us. One of our big accomplishments recently is the enactment of legislation in Arizona to set up a new civics curriculum, and that charge was led by her son Scott. So the family buys into it that this is perhaps her most important legacy. She thinks so. And I think if we reach her goal, it is perhaps at least on a par with her other legacies.
And can I add something? She loved going out in the early years of this to meet with young people, to address audiences, and to talk about iCivics, and they loved her. So that was very exciting. She got a lot of energy out of that. And I will tell one story on Julie O'Sullivan. So in the very earliest iCivics days, before it really got started, Julie took her son Danny up to the court, and they played video games with the justice. And the justice didn't know that much about video games, but she got very energized. And she said, well, this would be a great way to teach young people about civics. So it was really part of the extended clerk family that helped to launch it.
That is so important. This is a woman who didn't do her own emails, and now she's sponsoring video games because she says, that's where kids are. We have to go meet them there.
And I'm just jumping out of my seat because of someone that's
Carla.
involved with civic literacy and making sure that people have access to founding documents to be able, and the fact that she knew, even though she wasn't a techno person, that to reach young people, we have to use the tools of today. And to be open to that was just wonderful. And public libraries and school libraries all over this country are looking at iCivics and saying, we need to have that available on our websites and connect.
So Justice O'Connor really, really hated the term swing justice or swing vote, because she thought, I think, that it suggested some sort of ambivalence or indecision. But I have to say, in fact, in 25 years on the court, she was the fifth and deciding vote in 330 cases, at various points, I suppose, infuriating the right or the left. So I want to ask each of you, except for Carla, who's not expected to be a Supreme Court observer, what you think, in hindsight, will be her most lasting legacy as a decision in the textbooks, and if it stays around. Mm-hmm. So let me start with you, Ruth.
Okay, but just let me say here, I don't think she minded at all being the deciding vote. She just thought swing vote sounded kind of frivolous. I think she liked being the deciding vote. The court is changing so much, I don't know how many of her opinions will survive, but at least as part of the development, I think you'll continue to see attention to her opinions in the area of First Amendment, religion, separation of church and state, I think in the area of gender discrimination, and I think also that, at least as a part of the development, her decisions in the abortion area, I think, will survive.
Kathleen?
Well, I'm married to a law professor, so I actually asked what was in the textbooks. And I am pleased to announce that my two favorite decisions from our term are still in the textbooks 35 plus years later. They are Commissioner versus Tufts and Bliss Dairy versus United States. And I'm not seeing a lot of recognition in the crowd.
No, so why don't you
That would
tell
be
us what
because my husband is a tax professor, which I think is really kind of an important perspective on the justice, if I can just take a second on that. We were the first term after the justice had come on board. So 18 months ago, she had been on the Intermediate Appellate Court in Arizona, where I assume her federal tax practice was limited to doing her own return. And a year and a half later, she's writing these cases on federal income tax that are classics and are still taught to students because they're so important as contributions to an area of law that she couldn't have known.
Right. Let's move down the line. Linda.
So I think her most lasting decision was her earliest decision, Hogan versus the Mississippi Women's University, and Ruth was there for that decision. She came on to the Supreme Court of the United States. There were boxes of case files and stuff piled all around her office floor. She organized a system to try to get to the first conference in the fall so she would look competent, and when she got there, she found out that the justices organized their cases according to a different system than the obvious one. So at lunch, she had to run back and reorganize her case books, am I right? This is what she goes into. And in her head, she's saying, it's okay to be the first, but I don't want to be the last. And she gets a case, Hogan versus Mississippi, where the 8 male justices, are divided 4-4. So she has to make the 5th vote to decide whether it is unconstitutional to segregate public universities by sex. And she casts the decisive, not the swing, the decisive 5th vote to say that it was unconstitutional to segregate public universities by sex. In 1981, it was 15 years later that the court decided United States versus Virginia, the Virginia Military Institute case. So I would say she laid down her marker in the first term she sat. What courage it took to do that.
Have I missed anybody?
Yes.
Meryl?
Yes. So I think appropriate, because we're at a Reagan Institute event, it's a dissent in a federalism case, South Dakota against Dole. And it was one of the earlier coercive federalism cases. It was a case where she was actually on the losing side. But the important point is that she made the point that there's only so far that the federal government should be able to go in coercing states using the power of the purse, because there are so many federal grant and aid programs. And there's a linear projection from what she said in that case to some of the cases that are going on now, where the states are asserting their power vis-a-vis the federal government. So that was a very important early marker on coercive federalism, which is having repercussions today.
So I just have to tell one story here, because I often observe that it may be a gender difference, that she arrives at the court and she's just organized, she's got everything piled up. She does not want to be humiliated at that first conference, and she does everything to be completely up on everything. And Justice Scalia, who'd been a federal judge for a long time, arrives at the court at a similar time, just before the first conference, looks at all this stuff and says, I can't possibly be up on this, I'm not going. And he didn't. He went to the next conference. I mean,
Amazing.
women always have this idea that, you know, if you're there, you better do the job.
And that's where the first, even though a non-jurist, resonated so much with me, being the first, and the idea that you don't want to be the last, and you know that everything you're doing is being weighed in a different way. And so to have that joy come through, and I got a lot out of it just saying it, boy, she's something.
You know, Linda, although the two were often allies, Justices Ginsburg and O'Connor had very different approaches to judging. Could you talk about that difference?
So that actually is responsive to your first question about legacy. Justice O'Connor was, I loved what someone said earlier this afternoon, in some sense the heir to a common law judging tradition. And so she is making decisions in very much a case-by-case way, and each one confined to its facts. This is going to constrain her legacy, okay? What is an undue burden on the right to choose abortion, right? Justice O'Connor had an idea in a case-by-case way as each burden came in front of her about which one was undue and which one was not. That's not something you can pass along very easily to your heirs. Justice Ginsburg came with a very well worked out liberal jurisprudence from her training at Cornell under Robert Cushman. She said it at her confirmation hearings. She said her vision of the Constitution was of an ever-increasing circle of inclusiveness, from the propertied free white men at the beginning to, most recently, let's say, LGBTQ people. So she had a big vision of of jurisprudence, of what should happen. Justice O'Connor had an incremental version. It was a product of their philosophies, or it's just life, that Justice O'Connor got to enact her vision into law, right? She had and Justice Ginsburg, not so much once she got onto the court.
You know, there's been a lot said today. I missed the first panel, I think, but I'm sure there's been a lot said about Justice O'Connor as the glue of the court, and the story that's in Evan Thomas's book about her persuading Justice Thomas when he first got to the court after his confirmation hearings to come to lunch. And he says that she's the glue that holds this place together. But the court was often very divided, 5-4, on the biggest cases. And I suppose the ultimate one was Bush versus Gore. And this was a case where O'Connor's idea of breaking bread will make things all better didn't quite work, right?
Not as well as she hoped. There was some reference earlier today about terms in which clerks became divided. And to understand how important this is to Justice O'Connor, you have to really keep in mind that it was really important for her that people be able to work together and that they could disagree but do so agreeably. And so during the condensed time period that Bush versus Gore was heard, the clerks really took sides. And this troubled Justice O'Connor because it went beyond judicial differences and philosophical differences. It became personal in the two groups of clerks. And this is the case, of course, she's spoken about most publicly about saying that perhaps the court shouldn't have taken it, that it did great damage to the court as an institution. So that was one problem for her, but the other was just this personal fallout, not among the justices, but among the law clerks. And so she tried to get everybody together at a cocktail party of sorts afterwards, but the strains were too great, and she couldn't bring everybody back again. And she's at least told me that that's one of her great regrets, that a case that perhaps shouldn't have gone to the court caused this kind of personal fallout.
There was I gathered there was close to a fist fight among the law clerks, who, of course, I'm not sure we should say should be forgiven for their youthful zeal, but at least they had the youthful zeal.
They had youthful zeal.
You know, in private, the kind of judge she was when she served on the court is so different from what we see today. And I'm wondering, Meryl, what made Sandra Day O'Connor a Reagan appointee, a states' rights advocate, a woman of the West? What, if anything, made her different from conservatives? She certainly thought of herself as a conservative, from conservatives on the court today. Yeah, I asked you.
So she has enormous empathy. And she really puts people in the center. People are at the center of the jurisprudence. And while she cares a lot about states' rights, when it's a balance of states' rights against the people, but the person wins out. And this was true in terms of her ability to make friends, but also in her jurisprudence, she's thinking about the people. And I went back, I actually looked at a chapter in Evan's book because I wanted to think a little bit about her role as a state trial court judge. And there's a story in there that I don't know personally, but if Evan wrote it, then I believe it, that she had to give a sentence in a criminal case to a woman. And it was a very difficult sentence. And he kind of whacked her. He gave her 5 to 10 years. And then she went back to chambers and she wept. So she did the right thing. She was just. But she also really cared about the people. And I think that that really marks her jurisprudence. It's a conservative jurisprudence, but it's a very humane jurisprudence.
It also has to do with how she took things on a case-by-case basis, because the people were very three-dimensional to her. We heard this all day. Her clerks were very three-dimensional to her. They said in an interview that I got for my book that it was hands down the happiest chambers on the Supreme Court. So I think that's probably a piece of it.
And in Bush against Gore, you know, she said it had to be decided. And this is part of her Westernness, you know, that sense that the buck's got to stop with somebody. It has to be decided. And that somebody is the judge. And that's another reason why I think that this influenced her interest in having young people understand the role of the judiciary, that it has the last word on so many areas.
Could we talk for a minute about, certainly Justice O'Connor was a trailblazer, but from the vantage point of social change in the country, what her appointment meant. I mean, I will speak here personally. I had covered the court for years at that point. And I had heard more than one president say that he would like to name a woman to the court. And it just never was serious. It never happened. And I didn't, frankly, I don't think I took Ronald Reagan seriously. It was my mistake that I took it to be a promise or a pledge that he was going to name a woman, and that he was quite determined to do it. And I mean, her confirmation hearings were the first that were televised. And I remember walking into that court I had not understood how much I resented looking at 9 men until I looked at 8 men and 1 woman. Yeah. So I thought maybe the rest of you, you know, she certainly had that burden, but it meant a lot to women in the country. I mean, things changed for women after that. It was like a spark.
They did. I've been practicing 7 years when she was nominated by President Reagan. And I think that women lawyers across the country just all had the same reaction. I mean, it was very emotional. It was finally, because we'd been hearing for years that for this position or that position or that position, women just didn't have enough experience. They just weren't there yet. They just weren't good enough to do this. I mean, I was a trial lawyer, and I heard all the time that that wasn't something that women should do. And now we had somebody, once she was confirmed, on the Supreme Court. That took away, in my view and the view of my women lawyer friends, any argument that women couldn't do whatever they wanted to do in the law. And it was a game changer. It was a tsunami. It gave us an argument to make when anybody thought that women weren't qualified to do something in the law. And it continued, you know, young girls, their mothers, their grandmothers, the letters that came to the chambers from all of these people. I can't think of anything in my memory that has been that definitive a change. Not that there weren't obstacles in the future, but that changed the attitude of people toward women in the law.
Kathleen?
I was just coming out of law school when this happened. And at the time, there were still a lot of things that were challenging for women lawyers. And having this happen let you know those were gonna get fixed. It might not be immediate, but in the long term, things would work out the way they should. It was part of my reaction. What I've seen over the years has kind of cemented that reaction in how important it has been to women of all ages. I've lost count of the number of little girls I've met who, when for some reason find out that I clerked for Justice O'Connor, and they want to tell me about how they dressed up in a black robe for their third grade presentation about some famous person in American history. And this is their person, and they're thrilled to meet me because I met her. And every time I have traveled with her or been out in public, women of my age and older will come over, obviously non-lawyers, so this wasn't just our profession, and say, "Aren't you Judge Sandra?" And it matters to them.
And she once, I was on some panels in upstate New York that were organized by the Roosevelt Library, and she talked about what it meant to her as a girl meeting and seeing Eleanor Roosevelt. I mean, there were so few women you could model yourself after. And by the time she left office, there were so many. Just in the law. Forget all the other things, reporters, scientists, whatever. But in the law, now you go into a state Supreme Court, there are many more women. Mm-hmm. There are many more women advocates. Carla, you've seen this, I take it, librarians have gone from the library and the card catalog to being the librarian of Congress. Role models make a difference.
And that's why Evan's book, and I'm going to get mine autographed right afterwards. I am a librarian. I did bring my own copy. The inspiration, though, and I read it cover to cover, of that being a first, the female, the collar, the lace collar, and I see Miss Arston, her mother gave her that first collar. Just being able to be female and be able to perform, and sometimes outperform, and the joy of that, it went beyond law. It really did.
Justice O'Connor served on the court for 12 years alone. Mm-hmm. I think all of us remember being the only woman somewhere, I for way too long. And it must have been incredibly lonely.
Mm-hmm. So she said she didn't want to be the last. And 12 years later, Ruth Bader Ginsburg appears on the Supreme Court of the United States. And very few people know this, but in the years when Ginsburg was in the D.C. Circuit and O'Connor was in the Supreme Court, she took more clerks from Justice Ginsburg's chambers than from the chambers of any other lower court judge. And when Justice Ginsburg arrived, Justice O'Connor wrote 1 million letters, right? This is what makes writing about her so wonderful, right, Evan? But there's a letter from O'Connor to Senator Goldwater, and she's just talking about, I don't know, some Arizona thing, saguaro cactuses or something, and in this normal letter. And then it says, P.S., it says, quite unprovoked, Ruth Bader Ginsburg is a very capable and knowledgeable justice. Just FYI, Senator Goldwater.
She did an incredibly generous thing when Ginsburg was pretty junior justice, and O'Connor was assigned the VMI case. Right. And she said to Justice Stevens, who assigned it, no, this opinion should be Ruth's. That is an incredibly generous thing, because that's a big deal opinion. When Justice Ginsburg announced the opinion, she cited that Mississippi case, and she looked down the bench at Ginsburg, and the two of them had this moment that probably nobody else in the courtroom noticed, but they did. That was all that really mattered. And it's sort of, I always thought it was kind of important. Linda, your book, you know, let me just say this outright. You're a lefty, and you're more in sympathy with, I think, Justice Ginsburg's overarching way of approaching the law. But you came to believe that O'Connor was the perfect first, as you put it. Why?
So this was O'Connor's personal impact on me, right? when I was writing the book about her and Ginsburg. And I started out, I don't want to admit, my lefty, pinko, New York, frizzy-haired. But as I got to know her, as I learned about her character and her relationship with her law clerks and her relationship with Ginsburg, I came to revere her as a great political figure. It's so important that the person who's first be a great first. Otherwise, you have to start again. And the cherry on the sundae was when I was interviewing Justice John Paul Stevens, the nicest man in the world, may he rest in peace. And his book, Six Amendments, had some disagreements with some of the decisions that O'Connor had made, and I thought I had a scoop. And being a journalist, I am, of course, relentless. So I was leaning on Justice Stevens to say something critical of Justice O'Connor. And finally, he looked at me and he said, "Linda, she never gave us any trouble at all about anything." And I thought to myself, she was the perfect first.
She never gave them any trouble that they knew of.
Right. And actually, that makes her the
Perfect first.
I wonder, Kathleen and Ruth and Meryl, you all knew her for have known her for an extended period of time, when she was on the court and off, and when she was first on the court. And that's a kind of a huge span of years to observe someone. Mm-hmm. And how did she do that? I mean, she was not a shrinking violet at all. And yet, Justice Stevens said she never gave them any trouble, as I said, that he knew of. Mm-hmm. I'm sure she gave him plenty of trouble, but he just didn't know it. Yeah. Meryl, you want to take a whack?
Well, first of all, she was relentlessly charming. She charmed everybody. I was at an event with her at Hunter College in New York, and my mom, who is the inveterate New Yorker, came, and she said, "Are you Meryl's mother?" Oh, and my mother felt like $1 million, and she could do that. I mean, she made everybody feel like they were the most important person in the room. And that was a gift, and that was a real politician's gift. And that's another thing that made her a perfect first, along with her beautiful children and her handsome husband and, the junior league and all of that. So, I mean, she was sort of quintessentially American.
But Kathleen, let's face it, she could be really bossy.
Oh, yeah. Well, that goes with having life tenure and being able to make those decisions, right? And she was, I wish I could put my finger on exactly what it was that worked for her, because I would do that too. Certainly the kinds of things that Evan flags in the book, that she didn't have bad things to say about anybody, her ability to make people feel like they were the center of attention, and her ability also not to fight. And I think it's partly what everyone was talking about earlier today, not picking big fights that she didn't need to, but she wouldn't necessarily disagree with you in a casual conversation if it didn't need to happen, with the result that you always felt like she agreed with you, and therefore she was smart, you were smart, and everybody got along. Yeah. It was great, but it's sort of a magic combination that she had.
Yeah. And I never saw her, obviously, working with the other justices to get votes, but I saw her in other groups of men, and she was just masterful. She was able to make everybody think that they were in charge, and then they would come out exactly where she wanted them to be. And it's a real skill, and not many people can do that. But by the way she asked questions, by the way she agreed or sort of disagreed, but not in an unpleasant way, she always got people to where she wanted them to be. And I suspect that that's what she may have done with her brethren on the court, too.
And people talk about the Scalia-Ginsburg friendship, but there also is the great O'Connor-Breyer friendship, which crosses ideological lines. And they worked together on civics education, and they greatly admired each other.
Well, they were both, Breyer and O'Connor are and were much more incrementalist justices.
That's right.
They are not huge, broad stroke people, which Scalia certainly was, and other people are today. So it sort of, Breyer once said to me that even though he disagreed with her, not infrequently, they thought the same way. And I think what he meant by that is that they approached the problem in a much more practical, what Jeff might call common law kind of way, and realistic kind of way, to understand the problems that this was going to create or solve or prevent in the cases that they were dealing with. Carla, you are the perfect bookend in a way for this panel, although we'll continue to talk a bit. But because Justice O'Connor's papers are housed here in the Library of Congress, and not every Supreme Court justice has done that. So why did she choose the LOC, as you all call yourselves? How much of these papers will be public? How soon? And can you explain the reasons for her decisions about the papers?
I do want to start by saying that Justice Marshall's papers are here as
Right.
well, and Scott Berg is currently working on a biography to be published. And Mr. Thomas, of course, had access to the papers that are at the library, and right now the papers are available with permission. And we're working with the family. And that's not unusual when the person is still alive, and there are different people who are in some of the papers that are also alive. And so that's what we're working on now, but they are being very carefully maintained and stored. And
So when can I see them? And Linda wants to see them too.
I think I have something going here.
Listen, we're pushy broads.
But it's arrangements that you make with the family and with the person. And so we're working on that now. But this book, I think, gives you such an insight into what things are available and how they can be mined and what can happen when that legacy is left to an institution like the Library of Congress. And so we're very honored to have the papers.
Did Evan and OC pay you for that?
No, but
So
I'm getting that autograph.
So, Justice O'Connor, at some point, I would say maybe 7, 8 years ago, she did begin to lament that her legacy was being dismantled, that a lot of the things that she thought were good compromises and realistic compromises and were settled were getting unsettled. And I wonder, I saw you nod your head, Ruth. She was less cautious than she had been about making that pretty clear. And I think it concerned her, but I don't know if it was what she was worried about in particular.
Well, I mean, I think when she started talking about it, she said, things might change. But I think what was troubling her, and I'm filling in a lot of interstices here, she didn't say this to me, but I think what troubled her was that the approach that we've all talked about, her incremental approach, her trying to look at things within the four corners, is being abandoned in many cases by the current court. And because she believed strongly that that was the way to develop the law, then if the way of developing the law changes, I think she sees some danger in that. She was an incrementalist, not because she was afraid to be something more, but because she believed that was the best, most reliable, most fair way to develop the law. And so I think it isn't the fact that her opinions are being overturned as I think it is that the approach has become very different. And I think that would be troubling to any of us who thought we had done something the best we could and had found a way that worked, and to see it being sort of discarded.
Anybody else?
It's hard. I wish we could end this conversation by remembering that she's made a cultural contribution of such enormous moment. I ran into one of her law clerks at an event for my book after the law clerk wouldn't talk to me when I was writing the book, who shall remain nameless. And she said to me she could never walk down the block to go to lunch with Justice O'Connor in under 20 minutes because on every block they would get stopped 5 or 10 times by people who wanted to shake her hand, girls, by women who wanted to shake her hand. It's a good thing there weren't selfies at the time. I think we should hang on to that positive legacy of what she meant to those girls. This was late in her tenure, so well into the 21st century.
And what she means to women now.
Right.
The fact that an African-American librarian, career librarian, could read this, get inspiration, get some tips, how to do it, is a legacy that is immeasurable. And that's universal. That speaks to people on an entirely different level. Things change, laws change, whatever changes, but inspiration doesn't.
And I think that's all tied up with what she's doing with iCivics, which, for her is a statement of faith in the future and sort of doubling down and reinvesting in our democracy. And those are important parts of her legacy, too.
And another thing that we've heard referred to so often today that I think is unusual legacy, perhaps for someone of her position, is the true, deep affection that people have for her. People who knew her slightly and people who knew her well. And that's a lasting legacy. That's something that goes beyond any other structure there is, because that speaks to her as a person, and surely that's an important part too.
Carol?
The educational function just runs through as a theme throughout her career, and the educational function of the opinions, the educational function of what she did in iCivics, the grueling schedule that she has kept up until recently in her post-court career, where she just went every place and spoke to audience after audience, because she felt it was so important to get out that message of compassion and the devotion to democracy, and it shines through every time you see her appear in public. You see that. So her testament is not only what she says, but the fact that she's willing to go out and say it herself to people.
Even the way she closed out her public life was such a, she talked to the people of the country to let them know why she was disappearing from the public stage, which was an amazingly unselfish thing to do. And it always struck me that, yes, she could be bossy, but she was an incredibly unselfish human being. I don't know when she slept. I really don't know when she slept, given all the many things she did and her incredible energy. And even in illness, when she had breast cancer and really looked just wan and gaunt and sallow and never missed a day on the bench, and then advised Justice Ginsburg how to handle her chemo when she got sick. You schedule the chemo for Friday, then you have the weekend to recover, and you're back at work on Monday, and you're still in your chair, and so nobody's going to say you're not there. Her performance in public life was an amazingly, profoundly culturally effective and unselfish performance. And with that, we're going to quit 36 seconds early.